I've written numerous articles on this very topic. The bottom line is there are a number of cautionary aspects which attorneys especially must be on the lookout for when they're advising clients before an admission of guilt fine is paid. In terms of Section 57 and specifically also Section 57 capital A of the Criminal Procedure Act 51 of 1977 as amended, every accused person will have the benefit of paying admission of guilt fine instead of going through the long drawn out costly litigation process of a criminal trial. But as I have warned and in my articles as well, it should entail a cautionary approach by practitioners. Every practitioner might be aware of the fact that there was a recent court case in State v. Tong, a Western High Court case where the judges in no uncertain terms expressed the view that attorneys must be warned of advising their clients to merely pay an admission of guilt to get rid of a court case. In other words, this sort of shortcut approach. It's ill-considered. Sometimes it can even amount to malpractice if you advise your client to merely pay for the sake of getting it out of the way. Now, by that I do not suggest there are not any merits in advising a client from time to time to pay admission of guilt fine. Obviously, one must be on the lookout, advise your client of the pros and the cons of paying admission of guilt fine. Sometimes, obviously, there are other avenues to follow. One could also consider Section 105 capital A plea and sentencing agreement. But once you have decided to pay an admission of guilt fine, your client must be aware of the fact that the end implication of it would be that he or she will then have a criminal record. And as we all know, sometimes it will haunt you later. Be cautious about it. What I say is it is not a straightforward answer. Make sure that you advise your client to at least sign an indemnity form for you as a practitioner. Keep it on your file. Make sure that your client is advised of his or her constitutional rights, inter alia the right to have a legal representative available, to have the state prove its case beyond reasonable doubt against you, etc. Section 57, as well as 57 capital A, deals with two aspects in the criminal procedure. First of all, 57 without the capital A suggests that any accused person is afforded the opportunity to pay an admission of guilt fine instead of appearing in court and going through the lengthy process of a court trial. Section 57 capital A deals with the situation where a person appears in court, but before proceedings in terms of Section 106 of the CPA Act, he or she decides then to pay the admission of guilt fine. In terms of the Criminal Procedure Act, the moment you pay the admission of guilt fine, it is considered on equal basis to a plea of guilty in a criminal trial, meaning that by implication, obviously, you will now suddenly have a criminal conviction, which will be registered against your name, and having a SAP 69 criminal record will obviously, on the long run, result in persons not be able to get job opportunities, maybe be in a position not to apply for visums in some of the states they want to entertain for holiday purposes, etc. Many young practitioners, especially them, do not understand the implications of paying admission of guilt fine. Obviously, when the police approach such practitioners, they are easily and eagerly advised to pay the admission of guilt fine, get rid of the case there and then. In other words, it's basically a shortcut approach. The gist of the matter is, do not fall into that trap. Wait, advise your client properly, properly consider the pros and the cons. Sometimes it is in the best interest of your client indeed to pay admission of guilt fine, and obviously refrain from going through a long drawn out trial. On the other hand, and in most instances, once your client have attentively listened to your advice and obviously adhere to the constitutional principles entertained in a criminal trial, then obviously they are not that eager to pay the admission of guilt fine. Sometimes, but not always, obviously, rather go through the drawn out court case, get an acquittal, and obviously Bob's your uncle. End of story. Your client has no criminal record. But in comparison to that, once you have paid the admission of guilt fine, make no mistake, it is as if your client have admitted guilt, pleaded guilty. It is considered on equal par to a plea of guilty in a court of law. Therefore, the results will be that your client's fingerprints will be taken. It will be sent to the Criminal Record Bureau of the SAPS, and forever and a day, your client will have a criminal record. My advice to practitioners out there is always to ensure that they cover themselves. By that I mean, get a criminal a statement from your client in writing, preferably under oath. File it in your court file. File it in your own file. Make sure that you have properly advised your client in writing of the outcome, the possibilities, the alternatives, and ensure that your client gives you a written mandate to proceed and to pay the admission of guilt fine. Obviously, we would not like to see a situation where colleagues will have to stand in court before a judge to explain why they should not be held accountable for malpractice. And we all know, having a look at inter alia, the Tong judgment that I've referred to earlier on, what the implications could be and the end result. Practitioners might even be in a position where they will have to feed the costs involved in setting aside that initial payment of admission of guilt, etc.